Good morning, dear colleagues. Good morning, dear candidate. Good morning. Welcome at the second stage of the selection procedure for the High Qualification Commission of Judges of Ukraine. At the interview stage, the interview is held by all members of the commission, and let me introduce members. These are Tadeusz Rzeczny, me, Ivan Mishenko, Serhiy Verlanov, Robert Brookhuizen, Yevhen Mezentsev, and Stephen Markman. The rapporteurs are Tadeusz Rzeczny and Serhiy Verlanov. A couple of technical issues we should consider before we start our interview. If, for some reasons, the interview is terminated because of lack of electricity, air alarm, or other things, we will get in touch with you. Some staff of the Commission will get in touch with you, and we will determine when we continue the interview with the point of time where we stop. So don't be concerned about that, and just keep your mobile phone close to you for the Commission to be able to reach you. The second point is that we would ask you to give clear, concise answers to the core of the matter, and the member of the Commission asking the question is entitled to limit the duration of your answer. At the very beginning, you will have a chance up to 5 minutes to tell about the things you consider to be the main ones about you, about your motivation, about the ideas you have got concerning the High Qualification Commission of Judges, so the key things you consider important to share with the Commission. So welcome, and let me give the floor to rapporteurs. Please, dear colleagues, the floor is yours. Good morning, dear commissioners. I'm Viktoriia Bereziuk. I was born and actually grew up in the Dnipropetrovsk region, and after I got secondary education, I entered the National Academy of Law, named after Yaroslav Mudry, in the city of Kharkiv. I graduated with honors, and after that, since I studied at full-time studies department, I was allocated to the investigative department of Novomoskovsky militia department, where I worked as a investigator. I also entered Dnipropetrovsk State University of Internal Affairs, the Postgraduate Studies Department, and stayed at the Department of Criminal Procedure. I worked as a lecturer, and since 2008 I've been working in court, holding different positions. First I was consultant in court of Novomoskovsk City District Court, then I worked as assistant judge since 2012, and since actually 2012, I've been working as a judge. Before that, I was an assistant. Besides that, I'm the lecturer of the National School of Judges of Ukraine in the Dnipropetrovsk regional branch, and I'm the judge rapporteur of Novomoskovsk City District Court, and I've completed my work at the CITES. The presentation was supposed to take place in March 2022, but because of the full-scale invasion, it did not take place because I graduated from Postgraduate Studies Department at the Institute of Researching the Problems of Criminal Justice affiliated to the Academy of Legal Sciences of Ukraine. And territorially, this institution is located in Kharkiv, and it's well known that in March, Kharkiv was in the area of active hostilities. That's why they postponed my presentation, but all the organizational issues have been completed. We do have the scholarly council, and I will most probably have the presentation in February 2023, at the beginning of February. While passing a decision to apply for the selection, I was guided by the fact that currently I have some general experience working in the field of law of about 19 years. Actually, in April, it will be 19 years of experience. And this experience actually consists of lecturing, practical, scientific experience. This means that I have worked in almost all the fields of the legal profession. That's why I decided that if I have such an opportunity, I should participate in the selection. Besides that, I was motivated by the fact that I truly believe in the future of our country and in the future of our judiciary, in spite of the fact that, of course, we are facing a lot of problems, but we have to settle those problems, those issues. And when I was compiling my motivation letter in March 2022, that was actually the outbreak of the war. And so far, our country is still in this state. It has been in it for about a year. And in spite of this, the judiciary keeps working. In complex conditions, under strikes, under power outages, in the conditions of air alarms, but it keeps working, it keeps operating. So I truly believe in the future of the judiciary of Ukraine. Thank you for the question. So I've been lecturing at the National School of Judges since 2016. The disciplines, the subjects, and the trainings I'm delivering are related to sexual crimes, crimes against property, and also application of the convention of different conventions. I've been involved in training candidate judges, and on the basis of the results of such training, I also participated in the scoring, but only on the basis of the training which I delivered. Well, I was not the only lecturer within the training. There were several lecturers, so we together participated in the assessment, in the scoring of those candidate judges on the basis of the training. I did not participate in the compilation of any exams for candidate judges.
The sample questions or the draft judgments, did you have any involvement in that? The case studies?
I've not got the question, if you could rephrase it.
Yeah, sorry. I know that you were involved with some aspects of the examinations, but as you know, there are also case studies and judgments that the candidate applicants have to write. And were you involved in any way in the preparing or scoring the case studies?
No. I have not been involved in that scoring or assessment.
I took interest as well in the fact that you are the appointed speaker of your court, and that is a very important role, and I'd be interested in understanding your thoughts about how, as a communicator for your court, that will assist you in your role as a member of the HQCJ. Can you tell us a little bit about that, please?
Well, I think that the fact that I was elected to this position, and by the way, in 2017, 2018, and 2019, I was very active in this role. Besides performing my direct duties, which means communication with mass media in particular, I also held some all attendance or open days for school children, for students, where I told them what court is about, what court is dealing with, what judges and court staff members are dealing with this. Well, concerning the question how this will help me with the functions of the member of the HQCJ, is concerned, well, first of all, I think this will help me communicate in general, because the High Qualification Commission of Judges is a state authority, and the degree of publicity of the actions of the commissioners is much, much higher than the degree of publicity of one specific court. So the ability to communicate with the public, with mass media, is a precious asset, and I get that these skills will be helpful for me in this work as well.
Thank you. Judge Bereziuk, I'm going to turn you over to Judge Verlanov, my colleague, rapporteur, and he has some questions for you as well.
Good morning, Victoria. I'm Sergey Verlanov. Please, could you tell me, while we were studying your documents and we saw that you used to work in Dnipropetrovsk University of Internal Affairs from 2006 up to 2008, and your position was adjunct. Further on, I'm sorry, I cannot hear you. So let me repeat. I cannot hear you at all, no sound. And what about now? Can you hear me? So let's stop the interview. Let's stop. I can already hear you. Now I can hear, yes. Thank you. Thank you. Good. Good. So you can hear me now. Yes. So when the commission was analyzing your documents, we found out that you used to work as the adjunct from November 2006 up to November 2008 in the Dnipropetrovsk University of Internal Affairs. And further on, you were a lecturer at this university up to February 2009. But in your CV, you have also indicated that you don't have any academic degree or scientific title. So what are the reasons for that? You were an adjunct and you were a lecturer after you graduated from the adjunction office, but department, why didn't you get it? Well, that was related to some family circumstances. I was residing in Novomoskovsk, but I worked as an adjunct in the State University of Internal Affairs in Dnipro, and in 2008 I gave birth to a child, and I had to actually start working when the child was 8 months old. But since my son was very little, I had to look for a job in the town where I resided. That's why I had to leave the university, and though I was already the police captain at that time, but I came to the court to the first tier, to the first stop as a consultant, because I just needed some job in the field of law at the place where I resided. That's why I started working in a little bit different direction, starting with the position of the consultant. Okay, clear, thank you. And I wonder if you could tell me the following. In your motivation letter, you have indicated that you think that to improve the level of trust in the judiciary in Ukraine, in case you are appointed a member of the HQCJ, it will be necessary to settle the issue of qualitative and quantitative aspects of staff provision for courts. Let me specify the following. What do you think? What are the criteria according to which a judge should be examined for him or her to be selected? I mean, candidate judge, for him to be elected. Well, I think that the candidate judge must have high knowledge, good knowledge in the field of law, high moral and ethical values and principles, and besides that, impeccable reputation, positive experience of working in the field of law, and also this candidate should be a man of integrity, and integrity includes several criteria like independence, impartiality, and impeccable conduct, both in professional life and in daily life. And it's important that the candidate's standard of living and the standard of living of his family members correspond to the declared income. Thank you. What do you think? What should be the examination of the criteria of integrity for judicial candidates be like? Well, the criteria of integrity should be checked by specific examinations or inspections organized by the High Qualification Commission, also examination of the declaration and the documents that are submitted by the candidate, and also via an interview with the candidate. Probably also some other means could be used to do this examination. In particular, we could study the information about the candidate in social media, on the internet, since when you're appointed to the judicial position, it's important not just what you did over the last 3 and 5 years. The personality is developed and is maturing throughout the lifetime, and it cannot be the case that a person is good when at home and bad in professional life. I mean, in terms of behavior. And in spite of the fact that traits of your character are developing throughout your lifetime, in case it is established that the candidate some 20 or 15 years ago committed some act that does not correspond to the integrity criteria, so this would cast a doubt on our candidate. All right, thank you. Thank you. Ted, I don't have any other questions.
Involving driving vehicles in a state of intoxication, a situation, of course, which presents a very considerable potential danger to the public. The 13 cases were closed because the limitation period for proceedings had expired. And I'm wondering if you could comment about that, please, and explain to us the reasons for that situation in a period of 10 months.
I'm sorry, what years? What years did you mention? 2020, 2021, or which ones?
Yes, from September 2020 until June of 2021.
Well, I could explain this by the fact that these cases were considered before amendments were introduced. I mean, that the limitation of action was expanded, and the period is 3 months. So we should consider all those cases separately. Sometimes such cases come to court and they are allocated when the limitation of action is already expired. And besides that, the trial participant can make an request asking to have a break for him to conclude an agreement with their lawyer, and the court should grant such a request. But to tell the truth, I didn't try to make such statistics. Anyway, I think that if we take all the cases considered even under this article, this percentage is very low. I mean, a very low percentage of closed cases. Maybe really there were some circumstances in each of this case which accounted for the postponement of such cases. But to tell it exactly, I need to have a look at each specific case you have mentioned. In general, I can account for this only by the fact that there were some grounds to adjourn, to postpone these cases. All the cases arrived in court when the limitation of action was almost expired. Thank you for the question. Well, in 2019, I myself passed the procedure of qualification assessment, and I was acknowledged to be the one corresponding to the position held. And of course, I am aware of the fact that we have more than 2,000 judges who have not completed the procedure of qualification assessment. We have one judge like this in the court where I work, and besides that, the situation is made even more aggravated due to the fact that quite a number of judges who have not completed qualification assessment also don't have the mandate. I mean, that they were appointed for a 5-year term. The mandate has expired, the qualification assessment has not been completed, and this means that the judges cannot actually be administering justice. But they are within the court staff and they are getting their salaries. Of course, this situation cannot ever promote improvement of the judiciary and raise the level of trust of the society in the judiciary. And I think that completion of the qualification assessment procedure is a priority task for the newly established High Qualification Commission of Judges. Well, I do agree that the qualification assessment procedure is a critical one in terms of raising the level of trust of the society in the judiciary. And besides that, I think that currently, if we take into account the fact that some judges have passed the qualification assessment procedure while others have not, judges are not in equal conditions, but this means that the judges who have not passed qualification assessment still keep administering justice.
Okay, thank you, Judge.
Yes, just Judge Mezentsev.
Thank you, Justice Завзячне. Пані Вікторія, ви зауважили про
Victoria,
те,
you have
що ви є
mentioned that you
спікером,
are
так?
a judge speaker.
Ви чуєте мене?
Can you hear me?
Пані Вікторія, ви чуєте
Victoria, can
мене?
you hear me?
Пані Вікторія, ви чуєте
Victoria,
мене?
can you hear me or not? I cannot hear you. Now I can. You mentioned that you are a judge speaker, so here is a small question related to this. First of all, how often do you have to speak in mass media or at respective platforms like in Twitter or in Facebook in relation to coverage of the work of your own institution? And along with that, please tell us how ethical and correct it is for the judge speaker to utter their her own or his own judgment or opinion about the judgments passed in the court where he or she works. Thank you for the question. Let me start with the second part of the question. First of all, I think that it is inadmissible to give own opinion, not just of the decision and judgments of the court where you work, but generally of any judgments and decisions of other courts and other judges. Since when you are a judge speaker, you have to act on behalf of a state institution and on behalf of the courts. That's why subjective opinions are not an expedient thing to do, and I have never allowed myself to make them. Concerning my speeches at different platforms, I don't have any speeches at different platforms because communication with the public and with mass media is not my initiative. I am actually performing these duties in case there are public requests made to the court where I work, which means that if some mass media facility or outlet addresses the court, it is my duty to give the answers, so to have some communication with it. And my recent talk was with the edition Українська Правда, it was the one related to the high-profile case of our court related to the crimes, or rather to the crimes related to the cases related to the crimes of the wartime. And I was addressed by the correspondent of Ukrainska Pravda. We had some communication, and I provided the answers that could be provided within this case. But I didn't have any public speeches on different platforms. Well, because there is no demand for that, no request for that coming. And I have never had my own initiative to do this. And as far as covering the operation of our Novomoskovsk City District Court is concerned, so we work in this direction because we have a Facebook page of Novomoskovsk City District Court. And me and the press secretary of our court place some information there on the operation of our court. And in Sudova Vlada portal, of course, we also have some information about our court. Thank you for the answer. Let's assume that you're appointed a member of the HQCJ, and the judiciary and the commission have two challenges: to complete qualification assessment, which has not been completed for some reasons some time ago, of incumbent judges, and also selection of judicial candidates through which we have to fill the vacancies in the judiciary. Which of these two challenges, be it completion of qualification assessment or selection of new judges, would you consider as a priority? Which one would you start with and why? Thank you for the question. I think that the newly established High Qualification Commission of Judges of Ukraine should actually start with completion of qualification assessment of judges of Ukraine. And let me explain why I think so. The point is that selection of new judges, of judicial candidates, could take place after the High Qualification Commission determines the number of vacant places in courts. So far, our country is in the state of the war, and some territories are under occupation. Besides that, it's common knowledge that suppose in Kherson and Kharkiv region, some territories have just been liberated. That's why it's very difficult now to get clear about the number of vacancies we have and the courts to which can be administering justice now and which cannot be doing this for objective reasons. It's not possible to do this now for objective reasons. That's why I think that it would be absolutely logical to start with qualification assessment in case the newly established commission gets down to this task. It would be logical to start with completion of qualification assessment. Besides that, I think it's unacceptable that for 4 years judges have been receiving salaries but having no mandate and not administering justice. That means that somebody has to work instead of them, because a unit in courts, a staff member in courts, in particular small like city or district courts, is quite a lot of load. And besides that, the jurisdiction of courts of the territories that have been occupied has been transferred to some other areas, in particular from Donetsk regions like Kupiansk, Balaklia courts. So completion of the procedure of qualification assessment would help us determine how many judges will stay in their places, how many of them will leave after the process, and after that we will determine the number of vacant places, and then we will try and fill the vacancies. Clear. Thank you. And here is another question concerning political neutrality. This is one of the criteria you should meet, and we are going to assess you from this point of view as well. And political engagement of judges, of judicial candidates in the future. What do you think? Where is the limit of political neutrality? Could we think that adherence to some political movement or support of some political movement by a future judge, is this a violation of the political neutrality principle? And what would be the degree of engagement in political movement or support of political party that could be considered to be the fact that the person is not politically neutral. Thank you for the question. I think that the judicial candidate, the same as judges, should be political neutral, absolutely political neutral, by default. Every citizen of Ukraine has the right to be involved in the election, I mean, to participate in the election to the Verkhovna Rada of Ukraine, to local self-government bodies, to local council, election of the president of Ukraine, and judicial candidates and judges, as citizens of Ukraine, are entitled to participate in such elections and to vote secretly for the candidate they have selected, and the candidate they consider to be a decent one for a specific position. But as far as work is concerned, I think that there can be no adherence shown at all. I was appointed to my position by President Yanukovych, and qualification assessment was the process I passed in the period of Poroshenko, and I was appointed to my position for life term by Zelensky, but my work did not change because of that. I just worked as a judge. Thank you. Let me narrow down this question, focusing it on a specific thing. For example, if a judicial candidate has been involved in the election to the district council before becoming the judicial candidate, and he failed to be elected. I mean, it was not active but passive voting right. And he did this many a time representing different political parties. In this situation, is this candidate meeting the principle of political neutrality or not? Yes, I think yes. If it was passive participation, and this was done before, no, I don't mean passively participated. He was using his passive voting right. I mean, he was a candidate at the election, not just voting, but he was a candidate, but in different times and from different parties. But was he a deputy? No, he failed to. He was not elected. He was not decent enough to have the trust in the community. But he tried to participate in the work of the community via this election process, where he was a candidate for the deputy's place, and he did it in different times and represented different parties. It's not a simple question, that's why I'm asking it. Well, let me think a little bit. I think that actually you would need to work with this candidate a little bit more to collect some more information about him or her. But if we treat it the way you have treated it, I mean, if there are no additional stumbling blocks, I think that would not come as a barrier for him being appointed. Clear, thank you. No, I don't mind.
Experience, and therefore I believe I have the right to professional and career growth within the judicial system. When I was reading this, I was considering whether this is your only motivation, because often people apply for a job because not only they are motivated to make personal progress, but also because they believe that there should be changes made to their environment where they operate, and they have ideas how to make the environment better. But that apparently that is not your motivation. It looks as if your motivation is only a better job for yourself. Or did I understand this incorrectly?
Well, certainly I would be very much willing to have something to do with the process of introducing changes into the working environment of mine. Over 11 years of working as a judge, and also taking into account the fact that I'm a lecturer of the regional office that is servicing, so to say, 4 regions of Ukraine. This is Kirovohrad, Zaporizhzhia, Dnipropetrovsk, and Donetsk regions. I really have a chance and an opportunity to communicate directly with a lot of colleagues, judges, and therefore I would be willing to have something to do with the changing of the judiciary, introduction of the changes, revival of trust in the judiciary, in the society. That's why, of course, that would also be my motivation. This is another motivation factor due to which I decided to apply for the position.
But that is not contained in your answer number 1 in your motivation letter. Why is that so?
Well, the point is that motivation letter, well, first of all, it was limited in terms of the number of characters and the amount of information that could have been provided there. And also, well, I don't know whether it's relevant to mention this. I was writing my motivation letter in March 2022, and Novomoskovsk City District Court is the court and located in the territory close to Pavlograd and Sinelnikovsk, where in March 2022 there were active hostilities.
Okay.
And that was about 50 or 60 kilometers from the place where I work. There were artillery strikes. So I just wrote my motivation letter the way I felt it back then.
Okay. Okay, very good. We also asked you about your vision for the future, yes? And then you say, and I'm quoting from the English translation I have in front of me, you say, as for the public trust, it can be ensured only when every ordinary citizen will be sure that in case of violation of their rights and legitimate interest, they will be heard. Yes? This suggests that at present, likely they are not heard. Or is that not a correct understanding?
Well, this really means that currently the citizens of Ukraine don't have any certainty about the fact that in case their rights or legitimate interests are violated, they will definitely be heard. You know, while reading some information about the level of trust in the judiciary of Ukraine, and by the way, in our court, we also held some surveys based on questionnaires in relation to this issue. And while I'm answering your question, I would like to mention that the people who are directly facing the operation of the court and specific judges have higher level of trust in the judiciary and in courts. That's why, well, when I was making this statement in my motivation letter, I meant not the fact that the citizens of Ukraine are not heard at all, but that unfortunately, so far, they cannot be confident and sure about the fact that they will be heard in case their rights are violated, that they are heard by the state represented by the court, and that they will be, well, probably not helped, but heard, and that the case will be settled by an impartial and objective judge on the basis of the law.
There has been some research in Ukraine that alleges that ordinary citizens believe in 90% that they may lose a litigation from someone who is better off. and that is the basis of the lack of trust. Is this something that's also so in your court? And what have you done to change that in your position as a judge in your court?
Well, thank you for the question. I'm deeply convinced that in my court, the situation is different. Besides that, I think that if such a statistical study was held in Novomoskovsk district, I think that the level of trust in the judiciary would appear to be much higher than the average. Not because our court is the best court, but because in small provincial courts, the situation is better because reputation, impeccable reputation really matters here. I mean that if we take our small court, and I've been working there for 11 years, and before that I worked at the same place, in the same city, in law enforcement bodies, and you know, in such situation I cannot deprive any citizen coming to court of my trust. I mean, I need to ensure them that their case will be settled impartially, regardless of the position of these people, regardless of their religious beliefs, and regardless of the savings they have got. For court, everybody is equal.
Okay. Well, if you are appointed in the HQCJ, how are you going to make sure that this trust is elevated? You said just now in the answer of a question that you will do this by better selection, but you have not been explaining how you will do such a better selection to make sure that the people you select do have trust from the people of Ukraine. But just interviewing, you will not get there, I guess. Or maybe you can explain your views on that.
I think that what matters here, well, you know, the selection procedure is envisaged by the law. You need to collect documents, to collect information, to analyze information. That matters. But I think that one of the key criteria should be openness and transparency of the competition of the selection, because the judiciary of Ukraine has long been a closed system, and it is due to the fact that the citizens have an impression that this is kind of a corporate system. And let me tell you that I myself was not appointed to this position when I made the first attempt. But I think that this openness and transparency of selection of information about every single candidate is important. If a person has decided to become a judge, well, sorry, the degree of hiding information should be 0. Or at least it should be much lower than for an ordinary citizen. So I think that the more open and transparent these procedures are, and the more the High Qualification Commission of Ukraine informs the public about who can become a judge, and why some candidates do not meet the criteria. If it becomes clear for every ordinary citizen, there will be no questions in the society. There will be no doubts.
Okay. Thank you for your answers. I will
Thank you.
go back. You go back now to Ted, I guess, or to the chairman.
Yes,
the chairman.
Justice Mischenko.
Oh, thank you. Пані Вікторія,
Victoria,
це питання так чи інакше пов'язане.
I cannot hear you, sorry. This question is anyway related to the questions which have already been asked my colleagues, but let me still ask it. In your motivation letter, you have indicated that the issue of staff should be settled both in terms of quantitative and qualitative aspects, and I do agree with you, 100%. While indicating what quality stands for, you mentioned that people appointed to judicial positions should have high level of knowledge in the field of law, impeccable reputation, positive experience, high moral and ethical values, and so on and so forth. Again, I cannot but agree with you here. But what about the former members of the High Qualification Commission? Did they have problems with high-quality selection process? No. So can I already give the answer? Yes, please. So the former HQCJ didn't face any problems with selection. They had some problems with perception of those selections in the society. So what do you think the solution to this problem is? To make the selective procedure as transparent as open as possible and to inform the society state by stage as to whether this candidate meets the criteria or not and why the commission has passed its decision. And what will it look like in reality? Will you prepare negative conclusions, negative opinions of the judicial candidates who will never become judges? Will you indicate in your decision why this specific candidate has failed? Well, probably I will not indicate it in the decision why he has failed, but I will tell why he has not gone through, when he has not passed a certain selection stage. Clear. Now, concerning communication with the society, again, what is your suggestion? How do you arrange this communication? What should it be like? You claim that every ordinary member of the society should be aware of what is happening within the selection procedure. But how do you do this in reality? I don't mean that every citizen should be aware. Probably should have been the wrong word used by me, but is entitled to be aware of how the selection is taking place. I mean that if he is interested in that, he may find it out. He must have access to this information, and we must provide this access to information. And how we inform people about that? Well, through presentation of information on official websites, messages with this information which are published in mass media, I suppose, and publication of the results of specific stages of the selection. Is it not happening now? Or was it not happening when the former HQCJ operated? It seems to me that their interviews were also broadcast on YouTube. Well, the interviews, well, it seems to me that there has been no selection according to the new law. Or do you mean the qualification assessment? Yes, I mean qualification assessment. If I'm not mistaken, it was broadcast, or at least the plan was to broadcast them, and the plan was also to broadcast some of them in relation to the new selection procedure. Well, the point is that the selection was not broadcast. The first broadcasts were made when we started qualification assessment in 2016, but actually it was not yet related to the interviews because there was no new law. Okay, within this selection procedure, if we are already talking about selection, what should be the role of the Public Integrity Council? Generally, whether the Public Integrity Council has any role to play in this process. Well, Public Integrity Council should be supportive for the High Qualification Commission in terms of information collection about the candidate, and on the basis of that information, assessment will be made that this is a person of integrity or he's not. As far as the role of the Public Integrity Council, I still think that this body has a role to play, but if we speak on the operation of this body during the qualification assessment, I think it was to deal more with collection of negative information, but I think that while assessing a candidate, we need to collect both negative and positive information to really have a good assessment. But in general, Public Integrity Council has a role to play, and it should be supportive for the High Qualification Commission because it has this mandate. They can make requests, gather information, and send this information, refer this information to the High Qualification Commission in the form of information or opinion, in case there are some major considerations behind that. Clear? Thank you. You have also mentioned the so-called ratings or rankings of trust in the judiciary. And it's really true that a lot of surveys show that, unfortunately, trust in the judiciary is closer to the end of the ranking. On the other hand, there are some alternative surveys held in courts, and they show that the figure of trust, the level of trust is higher. And really, it's true that citizens, be it professional lawyers or attorneys at law, who undergo those surveys indicate that they have really had something to do with the judiciary, and their answers are much more positive. What is the reason, as you think, for such a difference, for such a gap in the results of different surveys? This is the first question. And the second question is, besides transparency and openness of the procedure, what else could be done for the level of trust in the judiciary, in case you are appointed a member of the HQCJ, to be rising? Well, let me answer the first question. No, not what is the difference, but why does this difference exist? Okay, why does this difference exist? That's because people who have had something to do with the court, who have participated in different court proceedings, are more objective in their assessment of what is happening. But, well, again, objective is probably the wrong word because they are assessing the work of the court by the judgment, by the decision, and by the process in a specific case. But anyway, they can substantiate their idea with some specific examples, while the surveys which are held by the among the people who have never entered court premises, well, if we speak about those people, their opinions are based on the information they get from mass media or from some other sources of information. And that is also quite a problem, quite an issue that needs to be settled at the level of legislation, because the reputation of the judiciary definitely depends on the activity of every single judge in his or her position, but it also depends on how much the state allows to take some actions that would tarnish this reputation. So I think that this issue could be settled through amending some legislative acts of Ukraine concerning introduced responsibility for ungrounded criticism of the judiciary. Maybe that could be done in that way. I'm sorry, could you remind me of your second question? Was it about improvement of the work of the High Qualification Commission, or what was the question? Well, the second question is how you, as an experienced judge speaker, whose role is to deal with communication of the court with the society, how and where do you see the solution to this problem of a poor level of trust? in your case, in case you are appointed a member of the High Qualification Commission of Judges of Ukraine, what do you do for this level of trust to increase? Besides openness and transparency you have mentioned, what else could be done to improve, to raise the level of trust in the judiciary among the society members, among ordinary citizens, finally? Well, thank you, but you know, the trust in the judiciary depends not only on the High Qualification Commission of Judges of Ukraine, that's just one component, a part of that overall system. And what does depend on the High Qualification Commission? Selection of professional judges who are people of integrity. Good. Thank you. There are no more questions. Thank you.
Questioning, although I think because you have the privilege of being the first candidate interviewed by the commission, we have taken the opportunity to ask many of the questions in the first round. However, we will conduct a second round of questioning, and therefore, Justice Markman, I turn the chair over to you for any further questions you may have.
Thank you again, Judge Zarzeczny. I would like to follow up on a question that Judge Zarzeczny asked when he last had the opportunity to direct questions to you. And these concern the drunk driving cases that was discussed earlier in our conversation. I think more discussion of this is warranted because as a result of what Judge Zarzeczny has described, large numbers of cases in this realm could not be resolved under the law of Ukraine, and as a result, large numbers of potentially dangerous people would remain on the streets of Ukraine. At least in my own prosecutorial and judicial experiences, these are not the most complex cases that a court has. They don't typically require lengthy investigations. And you, Judge Bereziuk, are, of course, absolutely correct that in order to reach a final judgment on these cases, you must look at the individual cases, as you said earlier. That's absolutely true. But nevertheless, is there not a concerning pattern here? Civil service society organizations have specifically identified this as a significant problem. And I think what they're suggesting is that you may have a particular problem in the area of these kinds of cases. That may not be a fair criticism, and I understand that, but that's exactly why I'm asking you if you could follow up and elaborate upon your understanding of these cases. Of course, you're right, we have to look at them individually, but it does seem as if there may be a pattern here, I believe.
Thank you for the questions. I cannot add anything other than what I have already mentioned. But I can tell you that the workload of Novomoskovsky City District Court indeed includes many administrative cases, not just those under Article 130. That's why 13 cases over a period of 1 year. Again, I was not conducting any analytical studies. I did not compile any statistics, but I believe this is a low percent from the general number of cases, administrative cases, that I have heard. But I do agree that cases dealing with DUI, well, these are cases that cause some response from the public. I do agree with you on this one, but the only thing I can say is that if I made the decisions that I've made, it was the only possible lawful decision to be made in those cases. But for me to be able to prove what I'm saying is to have those documents in front of me, to have the specific cases in front of me, and unfortunately, I don't have this opportunity at the moment to refer to specific judgments. And plus, we are trying to hear cases in the shortest time periods possible. But again, if there are some requests that we have to take into account, especially those on the where we have to call for some witnesses or where we need to provide some additional evidence if a person denies their guilt. Well, I don't have any grounds not to comply with such demands because we have to look at all the aspects of the cases, and a protocol available in such cases is not proof that this person is 100% guilty. That is why if there are grounds for that, definitely these people are charged in such administrative cases. But if I've closed some of the cases, if I made a decision that the proceedings should be closed on the grounds of lapse of statute of limitations, then I believe that I had grounds. I had my motives to make this decision.
Let me ask you one final question, if I might, on the qualification assessment process. I asked you about this earlier, and my colleagues, Judge Mientsev and Judge Mishenko, have also asked some questions that pertain to that process. You indicated in response to my questions that you had earlier gone through that very process. I don't recall the exact time, but you said you had gone through that process, and you were obviously successful, and I congratulate you for succeeding in that process. But let me ask you, what did you learn from that process? Was it an easy process? Was it a probing process? Were they asking the right questions? What would you do if you were on the other side of that process and asking the questions as opposed to answering the questions?
Thank you for the question. Yes, indeed, I have completed my qualifications assessment in 2019, and I cannot tell you this was an easy experience for me, because in general, it was up for the qualification assessment to decide whether I would keep my position as a judge. So it was quite a stressful and an easy process for me. But I cannot tell you that I had any questions to the commission or to the procedure itself. While I answered all the questions, I provided additional clarifications, I provided some additional documents if necessary. Yes, indeed, I had to look for some documents that could confirm events that could take place some 10 or 15 years ago. It wasn't that easy to do, to find these documents. But since I was the person interested in the outcome of the procedure, I was able to find those documents. I was able to provide the necessary proof. So in fact, there were no questions, additional questions. So I had all my answers to all the questions that I was being asked. So I provide all the documents, I had all the proof that I needed. That's why I was successful in passing my qualifications assessment. I was a little bit stressed during the interview, but in the end, the outcome was positive.
Thank you, Judge.
May I add?
Yes, Judge Mizenko.
Дякую. Пані Вікторія.
Yes, thank you. Victoria. Continuing this very prolific topic of trust in judiciary that we have raised on a number of occasions today, please trust me, we are touching upon this topic not in vain, because we are trying to find ways to come out of the situation that we are currently having. We are trying to enhance the level of trust. And should you become a member of HQCJ, it will be your task to think about this question on a daily basis. I hope you will agree with me that not everything in trust in judiciary depends on one specific judge, on whether they are being honest, transparent, on whether they are able to make just and lawful decisions. in many aspects, the trust in judiciary depends on whether judicial judgments are being implemented. So we, as judges, are providing a service of administering judges in the society and for the society. And that's why whether there will be some logical conclusion to any judicial judgment, that's the core aspect when we are talking about trust in judiciary. People don't trust the judiciary if they know that the decisions are not being implemented. And unfortunately, the practice of the European Court for Human Rights tells us that in Ukraine we have very many judgments that are not being implemented. So that is the main reason. It's not that the judiciary is not operating in the right way, but that the judgments are not being implemented. With all due respect to people that are administrating justice and with all due respect to the judiciary system, I have this question. What is your opinion about enhancing the efficiency of implementation of judgments in Ukraine? Not one specific judgment, but the whole body of judgments overall. So what could be done to overcome this kind of practice? Could you please provide 1 or 2 examples, if you can? Yes, thank you. I cannot but agree with you that making a decision is just the beginning of the process. For the judicial process to be complete, this judgment or this decision must be enforced and implemented. And indeed, the European Court for Human Rights has on many occasions confirmed the violation of human rights in this aspect. But I believe that for us to improve the situation with enforcement of court decisions, we need to introduce some changes into our legislation. Well, that's quite possible and obvious, but what would you suggest? Do we maybe need to have some more efficient charges? So what could promote the enhancement of the level of enforcement of decisions? Well, I think maybe we could simplify some of the procedures that have to do with charging debts, let's say. I don't know what else I can add here. Okay, so let me ask you a simpler questions. Back in 1990s, in the early 2000s, we have had this practice where judges received specific classes. So there were 6 classes, starting from class 5. And the procedure for these classes to be awarded to judges took place via quasi-qualification assessment that was done by High Council of Justice. It took place once per 3 or 5 years. So a judge was invited to an interview. Their work and performance was studied, the number of complaints filed against them. So they participated in an interview, and based on the result of such a qualification assessment or study, a decision was made on keeping the judge in the same class or awarding them a higher class or a higher rank. And that indeed affected the level of their salaries. So in your opinion, should we introduce a similar procedure of regular assessments for judges by the High Council of Judges or by the High Qualification Commission of Judges? And is it not going to pose a risk to the independence of judges that have been appointed for life? Thank you. Thank you for this question. I believe that awarding of classes or ranks to judges is not the best practice, and luckily we don't have it anymore. And to prove this position, I would like to ask you, what does it mean, a judge of a specific rank? Does it mean that it's somebody who's more experienced or knowledgeable? No, it wasn't about that. It was something that affected to your salary and was put on your employment record. So it did not affect the quality or number of cases that you were hearing. But the question about you keeping the same class or rank or being awarded a higher one, it went through a quasi-qualification assessment, so a judge was being invited to an interview. They were asked questions about their performance, about the number of cases they heard, about the complaints filed against them. So in reality, it was a kind of stimulus. I'm talking about myself here. It was a stimulus to look back on what you have done and also to think about the future if you wanted to get a higher rank or class. So indeed, it was a kind of disciplinary leverage for judges. And do you believe that we could introduce not classes or ranks, but maybe have some regular assessment of judges, once per 3 years, once per 5 or 7 years? And would it pose a risk for the independence of judges? So this is a wider context. Well, I believe that if we are going to have such regular assessments once per 3 or 5 years, that wouldn't pose a risk to the independence of judges. Thank you.
Can you tell me whether you have any experience with selection?
No, I don't have such experience of selection.
Can you tell me how you would...
I cannot hear you, unfortunately. I
Okay,
cannot
we'll try
hear you.
again. Yes, hello, no? No?
No. Yes, yes.
Okay, very good. Can you tell me how, if you would be appointed in the HQCJ, you would select people of high moral? How do you do that?
What do you mean, people with high moral and ethical values? Am I correct?
Well,
I have answered this question more or less, but if you follow this very specific criteria, then we should study some documents, some information about the candidate available on social media, in mass media. We can also conduct an interview. We can study documents provided by the Public Council of Integrity. It's a comprehensive process, actually.
yeah, I know the process, of course, but the question is whether that results in the selection of people of high moral. You believe it does. How do you know if you have no experience in doing that?
Thank you for this question. From what I understand, the experience of selection, only the candidates who have already been appointed as members of HQCJ should have such experience.
Okay, but
Where could I have gotten this kind of experience that
Пані
you're
Вікторія,
asking
скажіть,
about?
а коли ви ж самостійно
Victoria, but you are selecting assistants for yourself, right? Have you selected your assistants? And is it important for you whether this person is a person of high moral, if we are talking about your assistant? So if yes, what was your procedure of checking whether these person meet this criteria? Well, if we are talking about assistants, then we check their high morals in the process of their work. Unfortunately, prior to their appointment, there's no way for us to check. And plus, taking into account that we still have this problem with paying salary to the staff of the court, indeed, we don't have that many people that we can select from. But I only had 2 assistants, and one of them has already been appointed as a judge, and that was the sole reason for me selecting the second assistant for myself. And I believe that my assistants meet the criteria of high moral. And if to answer your question of how I measure their morals, I compare them to the values that I hold myself. And if their morals meet my morals, my criteria for high moral, then I believe that they are these types of people. Can we assume that you will follow the same procedures should you be appointed a member of HQCJ? So you will be comparing the candidates against your own values, against your own indicators of high moral? Well, to a degree, yes. Probably yes. If we are talking about HQCJ members, they are people who should meet this criteria of high morals. So. Well, why not? I think this could be one of the criteria that we can implement. If I have an understanding of what is good and what is bad, what is fair and what is unfair, and if I can explain it, then I can ask the same questions to the candidates. I can ask them what is good and what is evil, what is fair and what is unfair. And of course, I will interpret their answers with my own understanding of what good and evil is. Your position is clear. Thank you. I have no more questions.
Well, thank you, Judge Bereziuk, for participating in this process. We have agreed that the candidate should have the last word. And consequently, I would ask that you address us with any matters or issues that you think it would be valuable and important for us to have in considering your candidacy. The floor is yours.
Thank you. So let me conclude this interview with the following. I would like to quote Taras Grigorovich Shevchenko, the great Ukrainian writer and poet, saying, so, on the renewed land, we will not have the enemy, we will have the mother, the son, and we will have the people living happily. So I want to tell you that I believe in the future of Ukraine, which is independent, peaceful. And I also believe in the independent, just and impartial judiciary system in this kind of Ukraine. And I believe that our society deserves to have this kind of country and this kind of judiciary. So thank you for this interview. Regardless of the result, I do believe in the future of the judiciary in our country. Thank you.
And of course, Judge, so do we all.
I cannot hear you.
All right. I say, so do we all, Judge, and thank you very much for participating. With that, we will conclude this interview, and I will turn the matter over to our chairman.
Дякую, пані Вікторія. На цьому
Thank you,
співбесіда
Victoria.
завершена.
That's the end of the
Всього вам
interview for
найкращого.
you. I wish you good
До
luck.
побачення.
Goodbye. Unfortunately, I
побачення.
cannot hear you. Goodbye. The interview is over. Good luck. Best of luck to you. So I can switch off, right? Thank you.